to propose order for me to review regarding the litigate.
Yes. I will say this, Your Honor. Obviously, this case, we all know, we can see what's all around us right now. This case has generated a lot of media attention. And again, the state wants very much this case to be tried fairly, appropriately in a court of law. I will say this, just because information does make it into the media does not mean that it necessarily came from law enforcement prosecutorial sources. But I think that the state is in general agreement that we want to limit that so that, again, things are handled in front of Your Honor in the court.
So we'll prepare a proposed order and try to get this done. I'm sure we'll be agreeing on it and submit to Your Honor, hopefully by late this week or then.
Next, regarding sealing of motions.
Not all motions, but any motion which we believe we're discussing evidentiary materials. I mean, typically in a case like this, there'll be some concern about whether or not discovery obligations have been met. And we'd like to be able to not have to detail that in a motion and then subject to being filed with the court's office and used by the media to talk about what the facts may or may not be.
I think Your Honor, the appropriate way to handle that is that if Mr. Hartwell or the state files a motion and believes that it should be sealed, that they could file an accompanying motion to seal it. And then that would just sort of preemptively seal it until the court could address that order at that time. And,
That's the manner in which it's typically done. The motion and the motion to seal along with the motion.
I don't think we need a global order with that. I think we've done it all part of it.
Your Honor, maybe the easiest way to deal with this is if the state would do the same thing. If the state would agree to give us an advance copy of something they're ready to file, give us the ability to make that motion. We'll do the same. We won't file anything without letting it.
Just want it clearly understood that it's a public matter with a public trial, and certainly the matters that need to be sealed can be sealed to preserve the rights of all parties to a fair and impartial trial. And the court understands that, but at the same time, I want it clear that we will not have any private motion hearings. Public matters will be public.
Yes, sir, Your Honor.
Okay.
So we'll get your proposed order on that.
Yes, sir.
Can I move on to the next matter?
Yes, sir.
And that is, we filed a motion for speedy trial. We note that there are two terms here, one in October and one in November. And we'd like to go ahead and get this matter before the Charleston County jury as quickly as possible. Mr. Murdaugh does this for a number of reasons. One, as you've heard, he believes he's innocent. He avers he's innocent. And two, he believes that the killer or killers are still at large, and this would allow SWED to put this behind him and go look for the real killers.
Your Honor, the state, as I've already stated, is willing and actually completely agreeable to moving this matter forward expeditiously. I'm hesitant to set a specific term already because there is a very extensive discovery and probably a number of matters that will be needed to address. That could work out. I just think it's a little premature to say definitely that's the term we should schedule it. However, the state is absolutely in favor. The evidence in this case is substantial, and it all points back to Alex Murduagh. There's forensic evidence as well as all other evidence of his guilt of these murders, and so the state is ready and willing to move this matter forward as expeditiously as could be reasonably done.
And Your Honor, we understand that it's Mr. Waters' belief that the substantial evidence, both forensic and otherwise. Our response to that is he's wrong, and that's why a jury will sit in that jury box. Was it that jury box? That jury box. One of those, that's the grand jury box? No. Old-timey courthouse, I forget which side we go with. That jury box right there. Hopefully within 90 to 120 days to decide whether that is substantial evidence. Right now, there's October term with Judge Mullen, and she's recused herself, and November term with Goldsmith, Brooks Goldsmith from Lancaster County. Those are already set. I don't know that we need to get into that today, but we are going to be pressing for a trial as quickly as possible. In that vein, last week we served a discovery motion on the state. They have 30 days under the rules to respond. This matter's been under investigation for a year and a half. It may be extensive, but it ought to be easily easily accessible, and we ought to be able to get that in 2.5 weeks and begin the process of combing through it ourselves.
We've already provided them substantial discovery in the other matters, and we will certainly comply with our obligations. Your Honor, I think that once we start that process, and I know, and I agree that we need to move this matter forward expeditiously. What I don't want to have happen is for the defense to be screaming speedy trial on one hand and screaming about discovery on the other hand. This is a very aggressive timeline, which we're in favor of, but I think we need to see how things develop and find the most reasonable, expedited term we can. And I think we need to start this process for a few weeks and then make an assessment at that time of what is a reasonable term. That might be January. Obviously, Mr. Senator Harpootlian has his legislative obligations at that time.
Which I will waive. I will waive.
It seems like probably, given the realistic expectations in this matter, that January would be a very aggressive and reasonable timeline.
And we may disagree on that. But, Your Honor, I would point out they spent over a year investigating this. They took it to a grand jury. They should have presented them with all the evidence that would have convinced that grand jury beyond a reasonable doubt. And so it's there, it's accessible, you ought to be able, I mean, most of it's electronic, I suspect. They could hit a button and spit it out. We're not going to argue about discovery because I assume they're going to give us everything that would be scientific, everything under Rule 5, everything under Brady, and we're not going to have to fight about it. So we made a motion for speedy trial. I don't know that we need to, until Your Honor decides how to address that, there's no reason for us to draft an order on that. Is that correct?
As far as speedy trial?
Yeah.
I mean, again, I think we need to start the process, Your Honor, and then maybe reassess this matter in a few weeks.
Well, the defendant has a constitutional right to a speedy trial. That being said, however, I am totally unaware of the status of the docket here in Colleton County. I do not know if the Solicitor's Office for this circuit already has day certain trials scheduled or what other matters that currently exist that might be scheduled already or anticipated by, or whether a special term of court might become necessary to try this case.
And Your Honor, we will talk to people. Apparently there's no motion for speedy trial on any case pending in Colleton County right now. So we're the only ones to ask for one, if that makes a difference. And again, we understand it's totally within your discretion, not mine, not his. So we just want you to consider that. And again, I agree with Mr. Waters, it's not something we can rule on today. So thank you for all the That was everything the defense has for today. Mr. Waters just got additional matters.
Nothing further from the state, Your Honor.
Special Agent Owen, is there anything you would like to state pertaining to the matters here?
No, sir, not at this time.
Any victim input? Anyone wishes to address anything from the victim's perspective today?
We met with them yesterday. I've not been advised of any specific input.
Anything further then?
No, Your Honor, not for the defendant.
None from the state, Your Honor.
All right. The bond will therefore be denied, and matters discussed this morning will be addressed in written orders where necessary.
Thank you, Your Honor.
All right, thank you all.